Solution.
Next week, human kami acak memang. Nak boleh mau saya.
For admission, item number 1.
Please, Your Lordship.
Yes.
My senior is indisposed today, so kindly this matter may be adjourned for 2 weeks.
Yeah, please, Your Lordship. My lord, the last order is very clear not to grant further adjournment to the appellant, but I'm told that my learned friend is not keeping well. So I have no objection if the matter is adjourned for a short time. May I pray if it is convenient, Lordship, on 13 August?
13 next week, it will be very difficult. Any lengthy hearing, it will be difficult next
So,
week.
my lord, the matter is already infructuous. It's an infructuous matter. Our matter is, in view of the, my lord, decision, disposal of the 92 of the challenging the service rule. So from day one, our stand is, my lord, the officiating of promotion very clear that it's subject to the outcome of the BBC 92, and it is already disposed of. So the only issue is whether it is infructuous or not. That is the only issue. Of course, to your lordship convenient.
14, we can give a try. 14.
Lordship, yes.
But
Lordship,
I
after-
think
After 2 weeks, Your Lordship. Because
Because
my senior has difficulty, Your Lordship. He has some health issues, no?
okay, we tried on 14, but with with a big uncertainty.
the only issue is whether, since it is for admission, the only issue would be whether it is infructuous or not.
No, but since next week will be the last sitting of me and madam, so it may be difficult for us also to take up lengthy hearing matters. And then we give a try on 14th. If there is any difficulty, we can, if it is genuine,
Yes,
we
Your
can
Lordship.
still accommodate.
Yes.
Okay. Mr. Ayimchan, this time I hope I'm not wrong. Mr.
correct, Your
Ayimchan. The learned counsel for the petitioner.
Lordship, may kindly reflect the last order also, please.
Let us see the last order. Let us see. Okay, on 24/7/2024. The prayer of the petition of the appellant seeking for adjournment was allowed on the condition that no further adjournment shall be granted and an endeavor shall be made to dispose the case on the next date fixed. Stop. Today, when the matter is listed, Mr. Ayimchan, the learned counsel for the appellant, submits that Mr. C.T. Jamia, the learned senior counsel, leading the case, is indisposed and therefore seeks adjournment of the case for 2 weeks. Mr. Takamasa, the learned counsel for the learned
Respondent
senior
number
counsel for the respondent number
1.
1, however, submits that it will be in the interest of justice if the case can be disposed at an early date. since it is submitted that Mr. C.T. Jamia, the learned senior counsel, is indisposed. This court grants adjournment of the case on 14/8/2024. Listed accordingly.
Much obliged, Judge.
Next, Lordship.
Yes.
Lordship, I beg to mention item 13 from the hearing, His Lordship. I'm making mention of behalf of my senior
13.
Lordship, the petitioner.
Okay.
Lordship, if the matter come up After 2 weeks, Lordship.
On the prayer of Mr. Fuseko. How do you pronounce this FBFOTT?
Forte.
Forte.
Yes.
On the
Fuseko
prayer of
Forte.
Fuseko Forte. Learned counsel for the petitioner. Listed after 2 weeks.
Lordship. Are you obliged?
Your Lordship, I
Yeah.
beg to mention item number 12 on behalf of Inaholi. Kindly let the matter come up on Thursday, that is 8th.
Yes,
My lord,
Mr. MT, what is the
One-
matter?
this is for pension. This court has given a certain direction to my learned friend to get some clarification from the department. He must be with you for that.
Yes, Your Lordship, so on 8th, Your Lordship.
We'll list it next week. On the prayer of MS AIME, Learned Government Advocate. Listed again on 13/8/2024.
Much obliged, Your Lordship.
My lord, application item 11. This is for filing of a written argument, but I was out of station for some time, so I couldn't complete it. Can it be on Monday?
No, if that is the case, then we release from part head. You take your own leisure time. Let us see. But we release from part head. Okay, because Mr. Yangarwati is also not there.
My lord, I've spoken with him yesterday in the evening.
We'll fix on Monday. Let us see Monday, Tuesday, but we release from part head. Because next week, anything part head may be difficult for this court.
My lord,
Okay,
my lord.
on the prayer of Mr. On the, both the councils.
My lord, I've taken his consent.
Okay, on the prayer of Mr. M.T. Longchar, the learned counsel for the petitioner. Listed again on
12 or 13,
13/8/2024.
March of last.
Stop, release from part head. It's part head matter,
Yes,
release from part head. Okay.
March of last.
May I please, Your Lordship?
Yes,
My Lord, I beg to mention item number 14 and 15 on behalf of my senior judge.
14 and
15.
15, yes.
Can we fix this matter on 8th of this month, Thursday?
On the prayer of Mr. M.S. Swanso, learned counsel for the petitioner, listed after a week. Okay, we're not giving any fixed date. When it is fixed, you seek time. So this court will not give you any fixed date.
Acknowledgement.
Okay.
For motion item number 16.
16, yeah. Yes, Mr. I am Aliba Uzakam, I'm sorry again. Aliba Uzakam, you look very similar, so I always get confused.
Same height.
Same height,
Same stage.
same structure. Aliba Uzakam. Yes, what is your
Yes.
case, Mr. Ali?
May I please, Lordship?
Yes, yes,
Yes.
please.
Lordship, may I please give the brief summary of the case?
Yes, yes, please.
Lordship, here I was initially appointed as an LTA regular basis in the Department of DAN. So DAN is a development authority of Nagaland,
Okay,
established under the Down Planning Nagaland.
okay,
So it's a statutory body which is under urban development. So initially I was appointed in the year 2016.
urban development.
Yes, my lord.
Have you implemented the urban development?
No, lordship, I haven't implemented
Will it be
the
necessary?
lordship here.
Or
then-
this is a state within the meaning of Article 12 of the Constitution? Whether Dan is a state?
Then it is only a statutory body,
Statutory body, okay.
extract of the,
yes,
from the
just-
act, from section 73.
Just think over whether urban development will be a necessary party on the next date fix.
Yes, my
Okay,
lord.
Yes, so,
Okay.
so,
So I was appointed in 2016.
Okay.
Thereafter, I have been discharging my duties in different branches in the state office. And in the year 19, I've submitted an application to seeking for promotion. Thereafter, I also submitted an application in the year 2023 requesting to grant me promotion.
Are you the senior most
Yes, my lord.
LDA
Yes, my lord.
in the office of Dan
Yes, my lord, as an
Okay.
LTA.
as an
So,
LDA?
Yeah, being aggrieved by that, I have filed a writ petition before this court, which is pending. That is WBC 9 of 2024.
Ah.
That's regarding the representation, which is yet to be disposed by the authority. So in the midst of the proceeding, the authority have filed their affidavit in opposition, whereby they have incorporated this seniority list, which happens to be prepared in the year 2021, 10th of December, which was never known to the petitioner. But in fact, it was known only when the respondent authority filed their affidavit of opposition. I was shocked to see that.
Let us
there is
see
a
that seniority,
list.
which page?
Lordship is in page number 24, annexure I.
Page 20.
Lordship, this is the
Page
seniority
22.
list that they said to have been prepared on 10th of December 2021.
No, see, there are some LDAs who were appointed in the year 82. So you could not have been the senior most?
No, Lordship, that's date of birth.
Oh, is it?
Yes, my lord.
Oh,
The
okay.
subsequent following is the
Appointment
date
to
of
the
appointment.
present post, 17, 17, 17, 16. 18, 18, 17, 17, 16. Okay, you're right.
Yes,
You're right.
Lordship, and then Lordship may kindly see this, if I'm allowed to read this out. For any discrepancies regarding seniority, it should be brought to the knowledge of the authority within 1 month from issue of this order. If no such complaint is received, this order shall be treated as final. So there was no tentative seniority list prepared by the office.
Good.
So this happens to be the tentative as well as the final seniority list prepared by the authority. And then Lordship, the following line also to state that the promotion shall be made as per the vacancy arising from the branch, accounts and revenue branch shall be clubbed to one, and establishment and technical branch shall be another. So this was never in practice. This is the first time the authority have introduced this system, and that too without any formal notice or order from the authority. Just blindly with this seniority list, they incorporate all this notification, whether that is Lordship applicable or not. So being aggrieved by this seniority list, I'm here before this honorable court, Lordship.
Let's see your prayer. What is your prayer?
Lordship, I am praying, my prayer is at page number 11, 12, 10, Lordship. To quash and set aside the impugned seniority list dated 10/12/2021, to consider all the branches in the ministerial staff as one command cadre, and to maintain a common seniority list without distinction. Because Lordship, the seniority list which they have prepared shows distinction, whereas it's a clerical staff, Lordship. The LDAs are a clerical staff, a ministerial staff.
You mean to say that all the staffs are inter-transferable
Yes, my
from
lord.
one branch? to
Yes,
the-
yes. Those
That is
orders
how the
also-
department has been carrying on.
Yes, my lord. All along, I have been reshuffled 4 times, Lordship.
From one branch to
Yes,
another
my
branch.
The orders also annexed.
Mr. Ali Zakam, the learned counsel for the petitioner. It is the case of the petitioner that he is the senior most LDA in the office of the Development Authority of Nagaland, Dimapur. Stop. The petitioner is aggrieved by the seniority list dated 10/12/2021, issued by the Senior Executive Officer, Development Authority, Nagaland, Dimapur, wherein the seniority of the LDA in the office of Dan has been placed branch-wise, correct?
Yes, my lord.
It is further the case of the petitioners that all in the office of Dan should be placed in one common cadre and a common seniority list without distinction should be maintained. Issue notice to the respondents, returnable after 4 weeks. The learned counsel for the petitioner shall take steps for service of notice upon the respondent number 1, 2, and 3 by registered post with AD within a period of
3 days, Lordship.
3 days from today. In the interim, it is ordered that the seniority list of LDA dated 10/12/2021 and all consequential promotion made on the basis of the said seniority list shall be subject to the outcome of this writ petition.
Obliged, Lordship.
Yes.
For admission, item number 1.
Yes, Mr.
I'm-
Santi.
Lordship, I am here to file my reply, Lordship.
Yes.
If I can kindly be granted 3 weeks, Lordship.
You are always very prompt. What happened this case?
Lordship, the junior who is in charge of this brief, Lordship, she is preparing for judiciary exams, Lordship.
Oh, okay.
So which is
Okay,
how,
okay.
yes.
Mr. Santi Younger, the learned counsel for the petitioner, 6 for 3 weeks time
Yes, my lord.
to file affidavit in reply. Prayer is allowed, listed at court. Okay.
Obliged, my lord.
Item number 2.
Your Lordship,
Yes,
this matter has been recently endorsed to me, so if I may be given some time to go through this case, Your Lordship.
but this court has made an observation that no further adjournment shall be
Lordship.
granted in the case. What is the case?
Lordship,
Mr. Wati?
Lordship, I'm aggrieved by appointment of private respondent who is not a landowner,
Are you the landowner?
Lordship,
Are you sure?
Lordship.
And,
However, Lordship, by filing affidavit in opposition
Ah,
by the state as well as the private respondents, that more than 4 or 5 landowners has been appointed earlier. Therefore, no landowner exists. That is right of the landowner exists. That is the stand of the government as well as the private respondent. However, recommendation of the private respondent case has been based on the landowner, Lordship.
when the respondent number 4 is not the landowner.
Lordship. Even assuming that respondent number 4 is landowner,
Yes, madam, you are an encroacher. You are encroaching into the post of some, the landowners. You are not the landowner. If you are not the landowner and you have represented yourself to be a landowner, you have committed fraud on the government. Yes. You are supposed to answer this. Whether you are a landowner or not. Are you a landowner? Are you led by somebody? In this case? Are you led by somebody?
Yes, my senior.
Oh, who is this?
Lordship, a short time may be granted.
We list it next Monday. Okay, tell your senior to be here. And madam, also prepare and come Monday. It's, I think, a very limited, the case is very limited to landowner. Okay. On the prayer of the learned government advocate as well as the learned counsel for the private respondent. Listed again on 12/8/2024. Okay.
Item number 3 to 5.
Yep, we have this. Your
Yes,
Lordship.
yes, ma'am.
I'm preparing on behalf of my senior, Mrs. Gauhati.
Yes.
We have received counter affidavit filed by the state respondent and private
Ah.
respondent. So I pray I may be granted 3 weeks to file affidavit in reply.
You file your affidavit, private respondent, government?
Yes, Lordship.
Okay. Affidavit in reply to whose affidavit? Government? Government?
Yeah, yes, Your Lordship.
Okay. MS so-and-so, learned counsel for the petitioner submits them, she may be allowed 2 weeks' time to file affidavit in reply to the affidavit in opposition filed by the state respondents. Prayer is allowed, listed accordingly.
Item number 6.
May I please, Your Lordship?
Yes.
I'm appearing on behalf of my senior, Mochamir, the counsel for the private respondent number 6. Lordship, kindly grant 3 weeks' time to file counter affidavit.
What about government? You have filed?
The Lordship, last chance may be given to the private respondent number 6.
Okay. What is your case?
The Lordship, this case is regarding land ownership.
Land ownership.
Yes, Your
You are
Lordship.
the landowner
Yes, Your Lordship.
and respondent number 6 is not.
Yes. The private respondent was appointed out of nowhere.
Out of nowhere.
Yes, in the post of Chowkidar.
Okay, then let the government file the affidavit.
Government has
Or state, what is the stand of the state?
Lordship, I'm appearing on behalf of Muslim, so I'm with your lordship.
Mr. Your good name? So and so. The learned counsel for the respondent number 6 is allowed 2 weeks' time to file.
Lordship, 3 weeks' time.
Okay, 2 weeks, 3 weeks, no difference. Is allowed 2 weeks' time to file affidavit in opposition. Prayer is allowed, listed accordingly. Okay.
Item number 7.
May I please, Your Lordship?
Yes.
Lordship, here I'm appearing on behalf of M. Kasar, Your Lordship.
Then Kasar.
Yes, Lordship. Lordship, it is learned that the respondent has filed his affidavit, Your Lordship. However, I'm yet to receive that affidavit.
Who is the respondent?
Government advocate, Your Lordship.
Only government? Yes, government. Have you filed your affidavit?
Lordship, yes, the state has already filed.
You want to file your reply?
Once I receive that affidavit, Your Lordship, if necessary, I will.
You have not received.
Yes, Lordship.
This affidavit was filed on 30/7/2024. This is affidavit on behalf of respondent number 1, 2, 3, 4.
Lordship.
Why you have not been served copies? Who is the counsel?
Lordship, on behalf of Achun Lee. Lordship, I will inform.
Is he finding difficult to serve the copies?
On behalf of Achun Lee, Lordship, I will inform.
Lordship, here the petition, this petitioner M. Kasar is from Dimapur, Your Lordship. So the government must find it difficult to send it to the petitioner, Your Lordship. So
You will accept
if
on behalf of M. Kasar?
Lordship,
We
yes,
will give a deadline.
Lordship.
The learned government advocate shall furnish the requisite copies of the writ petition
Affidavit.
to file to furnish the requisite copies of the affidavit filed on behalf of the state respondents to Mr. Your good name?
Medovero, Lordship.
To Mr. Medovero, who shall thereafter furnish the same to Mr. M. Kasar, the learned counsel for the
Petitioner.
petitioner. Stop. The learned counsel for the petitioner is also allowed to file affidavit in reply, if so advised, listed after 3 weeks.
Obliged, my lord.
For orders, item number 8.
Your Lordship,
Yes,
on motion, This court has directed to serve the copy to respondent number 3. And there was some irregularities created. We have served through, not through High Court registry, but through the registered post. And on 30, on the last occasion, court has directed me to agree. So there was irregularities created. And my
Let
apologies to the court.
let us.
And on second, it was corrected and the respondent number 3 was served with the copies through High Court registry.
Have you served the notice upon respondent number 3?
We have served on second.
You have served.
Yes, we have
Service of
already
notice
served.
upon it has been issued. Right, issued, okay. Return service in respect of respondent number 3 awaited, listed after 3 weeks.
Okay.
Item number 9.
Your Lordship, this was similarities to that
Same.
irregularities, yes.
Service of notice.
And that has been corrected to the
Okay,
registry.
so same,
Your Lordship,
same position,
same position. Your
Okay.
Honor.
same order.
Obliged, Your Honor.
Yes.
For hearing, item number 10.
My lord, petitioner has filed an additional affidavit. So, lordship, I may be allowed to reply to that additional affidavit.
What is that additional affidavit? What is that? What is that additional affidavit?
Additional affidavit was filed as per the direction of this court. Now.
By which order? Let us see. By which order? Additional affidavit was filed.
Yes.
Your Lordship, is dated 7/5/2024.
What is the matter about, Mr. Imchin?
Lordship, they are seeking for compensation.
Compensation.
Lordship. Compensation. Impact and Patro.
Patro.
Yes.
Road construction or?
No, they are saying that the land occupied by the NST, Nagaland State Transport, has not been compensated. So I filed the counter. State has filed the counter.
Okay.
Now, on the prayer of the petitioner has prayed to file additional affidavit. They have filed
Additional
that.
affidavit for what?
Lordship, here they are saying the work order has been given to the landowners. However, the landowner, it was never born on that very period of time. Whereas the NST, the Nagaland State Transport, they have constructed the NST office as well as the quarter during the year 1976. And in the meantime, till date, Lordship, we have been filing representation over and over, and the compensation has never been paid to us.
You suddenly realize that your land is valuable.
Lordship, at that period
You
of
were
time,
sleeping over, you donated the land to the government. And the government had set up the NST office. And once you realize that the land has become valuable, you are claiming.
And Lordship, in the additional affidavit, they have made an agreement that no contract was given to the landowner. Whereas as per the record,
contract was given. So I'm bringing in that record. I've already prepared a reply to the additional affidavit. I'll be
Mr.
filing
Mohamchin, the
within a bit of
learned senior government advocate is granted two.
2 weeks time, Your Lord.
Is granted 2 weeks time to file rejoinder affidavit to the additional affidavit filed by the petitioner.
Of
Mr.
legislation.
Deputy. Okay. Yes, next.
Much obliged.
Item number 17.
What is? Yes, Mr. Imti Longchar, what is this case? 17. Mr. Imti Longchar.
No, it's ours, Lordship. Oh.
17 is Imti Longchar. You have forgotten your case also.
My Lord, Your Lordship.
What is your prayer in this petition? Let
My
us see
Lord,
first.
to regularize from the date of appointment.
Okay.
Yes. This court have given a clear direction to regularize the service of the petitioner.
Okay.
But the regularization is from a prospective date. The appointment is clearly against sanction post. So what I am bringing is that regularization should be from the date of initial appointment.
Let us see.
My Lord, earlier, Surendra Singh, it was from the net, which I enclose in the petition. But in the report also, the paragraph are not given. I'm placing two rulings. That is Karuna Sharma, which is a very short judgment. I may be allowed to read out, my Lord. The whole judgment is titled as first page. Whatever this application has been filed on behalf of the master rule worker who was appointed as far back as on 2/12/81 as a plantation campfire watcher. This is Annex 1 to the writ application in 84. The petitioner was transferred as skilled laborer to the office of the range officer Charuduar range. But till today, the service of the petitioner has not been regularized. Annex 3, 4, and 5 will show that the petitioner was holding the existing vacant post of plantation Mali, sanctioned by government letter number 26/88. It is an admitted possession that there is an existing vacant post in that also is sanctioned by the government. In that view of the matter, there can be no earthly reason as to why the service of the petitioner should not be regularized. On 2/193, the Divisional Forest Officers, Social Forestry Division, now Nalpari, if I am not. Also wrote to the principal PCCF, Assam Gauhati, that the petitioner even may be appointed as the forest guard in the division. Paratu, considering all these aspects of the matter in after hearing Sri Sajin Saj in Srimati Sajin Saj, I direct that the respondent number 2, 3, and 4 shall do the needful to regularize the service of the petitioner, either as forest guard or as plantation Mali in or any other suitable vacancy within a period of 3 months from the date of receipt of the order. The regularization of the service of the petitioner shall be made from 21/12, that is the first appointment, the date on which the petitioner was initially appointed. I am deciding to make the regularization from 2/12/81 as the petitioner is working in that post since that date. In considering the fact that the petitioner belongs to the lower strata of the society and subsequent point of time, there may not be difficulty to receive the pension at the end of his service care. The petitioner is saying from a poor strata in a woman. In this case, poor strata. Then this is 2 is
This 1995 1 GLT.
yes, my
You
lord.
have enclosed the judgment also?
My lord.
Okay.
That is page 4.
Ah.
The whole judgment has been typed out. Only null part in null party must be typing it.
Okay.
Then yes, null party. I may be stand corrected.
Then what is the WF 14K of 2022?
This was my case, my lord.
Ah.
What happened is that the
Where is this judgment WF 14K? Have you enclosed?
yes, page 5.
Page
Page 5.
Page
5 to
Mogule.
7.
Okay.
But I type out relevant portion, that is para 11. This lady also was appointed on fixed fee in compassionate appointment against the late sister's post. So when the single bench says that should be given the scale of pay from the day of appointment, the government filed an appeal. So this is the division bench. Para 11, in the case of Chamuna Dipama versus Rathi Shyam Das in another reported in 2010 4 GLR 441, it has been held that the validity of an order must be judged by the reasons so mentioned and cannot be supplemented by fresh reason in the shape of an affidavit or otherwise. The order dated 28/2, that is her initial appointment, 2006, has to be read on the basis of the contents mentioned in the said order. The order having categorically stated that the respondent was appointed on compassionate grounds in view of the death of her sister such and such, who was serving as typist in the Nagaland Civil Secretariat. The appointment of the respondent has to be deemed to be on compassionate basis. There can be no other interpretation. Accordingly, the appointment being made to a regular sanction post, the state appellant were bound to give the respondent a regular scale update as applicable to the post in which the respondent has been appointed. As a combined reading of judgment such and such and the order dated, my lord, 28/2, that is her appointment order, makes it abundantly clear that the respondent was appointed under the tie-in harness scheme against a regular sanction post of her deceased sister. The appellants are bound to pay the respondent the regular scale of pay attached to the said post. The appellants are thus directed to regularize the service of the respondent against the post of typist, which was earlier occupied by respondent's late sister such and such, who died in harness. Therefore, the state appellants shall pay the regular scale of pay to the respondent. The other one is which I include equal pay for equal work, which is in the writ petition. I may be allowed to bank on that without taking your lordship to the equal pay for equal work, which I includes as a nature in the writ petition. Judges saying is
You are asking for equal pay for equal work.
Malo.
With retrospective date.
Malo. From the date of appointment. Because the date of the appointment order itself is clear.
Okay, Mr. MK, let us go to the facts. One by one, let us see your petition.
Malo.
Yes, come.
First is appointment order.
Which page? Just wait, just wait.
Page 14, type copy is 15.
Just wait. Page 14.
My lord, type copy is 15. Srimati Sergeant Sarge appointed as sweeper in the office of the Sergeant Sarge, Mogokchong and contingency paid basis at the rate of rupees 375 per month. This is the scale of pay at that point of time, with effect from the date of her joining the duty.
This is fixed.
My lord, the next para, the appointment is made against the post sanctioned by order number Sergeant Sarge dated 9/6/88.
Okay.
So the petitioner is holding a sanction post from the D1, 26 October 88.
It is a sanction post, but you were not appointed against a sanction post.
No, the appointment is made against the post sanctioned by order 9/6/88.
You were appointed against a sanction post on a
My
fixed
lord,
fee. On a
that
fixed
is-
fee.
That is the order.
Okay.
And it is not been denied by the
Okay,
respondent
okay.
from the
This court
D1.
also is with you.
No.
Okay.
So whatever the petitioner applied on 16 February 2000 for regularization of service,
Where is that?
page 16.
Page 16.
I have the honor to state the following line for you, a prayer for your kind necessary action. That, sir, I was appointed as a work-yard sweeper on 26/10/88 with a fixed fee of rupees such only. And I am serving the department as the work-yard sweeper with the fixed fee for nearly 12 years. Under the circumstances, I pray your honor kindly to consider my long service and regularize my service with the scale of pay as regular sweeper, for which act of your kindness I shall ever be grateful to your honor.
So this application itself shows that you were never appointed on a regular basis.
No, the
Yes.
order is very clear.
Yes.
And I also made that clear.
You were appointed to a sanction post,
Malo,
but on a fixed pay.
Malo,
You were not regularized. That is why on 16 February 2000, you had actually applied to the government to regularize your service.
Malo.
Okay. Then
on 29 February, the same month, page
17.
Yes,
Page 17 and 18.
18 is the type copy.
Page 17 and 18.
Malo.
What is this, Mr. 18?
Srimati Sergeant Sarge is temporarily appointed as sweeper in the Directorate of Printing and Stationery, Naklang, Kohima, in the scale of pay of rupees 600 to 1475, plus special compensatory allowance, locality allowances at the rate of Sergeant Sarge to a minimum of Sergeant Sarge, maximum of Sergeant Sarge in all other allowances as are admissible under the rules from time to time in the state of Nagaland with effect from 1/3/2000. The appointment is purely temporary. At any time, the service will be terminated without any.
Okay, so by this order, you were given a scale of pay.
Malo. That is starting from 600, 29 February 2000. Then page 19 may be seen, Malo. This is all the same, 29 February.
19.
Page 19. February sign on 29/2 K. It is the same date. Only the difference is, my lord, the initial amount.
The scale of pay, 800, 600.
Yes, my lord.
Your Lordship, let me interrupt. These issues raised by my learned friend has been already, state has filed the counter and it has been already adjudicated by in read petition 215K 2018.
Okay, it's all right. Let me understand the case. I'm just trying to understand the case. This is also scale of pay.
My lord, only
Scale of
the,
pay.
yes, my
800.
lord, as your lordship has pointed out, only initial 600
Yes.
to 800,
This has been enhanced to 800.
my lord, but The sad thing is that the petitioner was not paid.
Not paid scale.
Yes, as per their own order. This order stands till today also. It is not been revoked by the respondent authority. So by annexure 5, page 21. Again, the petitioner applied for recolorization.
20 page.
Page 5, that is prior to recolorization. There are two.
Page 21 and 22.
My lord.
Page 21 and 21A. Correct.
21, my lord.
And 21A is the type copy.
No, this is 22 is the extension order.
21A. Page 21A.
My lord.
Is the type copy of page 21.
My lord.
Correct.
Sorry. 21A. My lord, must be the type copy, but it is not with me. Only the thing is that this is 10 February 2001.
Okay, so the type copy is not with you.
No.
But 21, page 21.
Yes.
Is 10 February 2000.
My lord.
Okay.
My lord. Then page.
Just wait, just wait. Yes. This is also for regularization.
Yes. Then the last order was 2001.
This is page 22.
Yes, still shown in the fixed spec.
Page 22.
Yes. This is extension.
Even on April 2001, you were paid a fixed pay.
That is what I'm saying, my lord. Actually, as your lordship has pointed out, in 2000, that is 29 February 2000, one was 600,
Correct,
another
correct.
was 800.
But whatever paid, you were paid scale of pay.
No.
No, by the order.
Order is yes, yes.
By
my
the
lord.
order,
Yes.
you were granted scale of pay.
My lord.
Though in practice, actually, you have not been paid.
No. Rather, 2001 extension shows it.
This is something very peculiar.
No, my lord, one fact remains that this
22 is, this is order dated 30 April 2001.
My lord, still shown as a extension in the fixed pay.
Where have you stated in your paragraph that you have not been paid a scale of pay?
My lord.
Despite the order?
Yes. Para 4 after the petition, page 4. Subpara, the two office orders are contradictory to each other. With that is me. The petitioner was never given skill of pay as per the said two orders.
Yes, MP, please.
So annexure 7, the petitioner approached this honorable court.
Annexure
7, WPC number 215 of 2018.
Why you have approached this court? Because you were not
For-
regularized.
For regularization, madam.
Okay.
Facts are given in para 4, which is the submission before your lordship. Paragraph 4 after the judgment order.
Para 4.
Yes, the facts of the case may be noticed at the outset. The petitioner was appointed temporarily.
Yes, what
as
was the
a-
direction given by this court?
Page,
Yes, what was the direction?
my lord, the direction was to regularize the service.
Let us see the operative portion of this order.
Page, para 13.
Para 13.
Yes. I may be allowed to start from para 12.
Okay.
From the above fact, extract, it may be seen that the respondent have not denied the fact that the petitioner was appointed against a sanctioned post. He, however, said that the relevant file could not be traced out in the department, in there being no vacant post at present. Her service cannot be regularized. That was their stand. They stand after respondent in their affidavit in opposition, among others, is that the regularization scheme does not include those employees who are engaged on part-time on contingency basis. In this connection, it may be said that the petitioner was initially engaged by order dated 26/10/88. Hence, she continues to be in her engagement till date. The same can in no way be considered as a part-time employment so as to apply clause 1 IJ of the OEM dated 17/5/2015. Moreover, the petitioner undisputedly has sought for her declaration by submitting her representation as early as 16/2000 in 2001 and also on 10/8/18. In terms of the direction of this court. In the case of Mohinder Singh Gill, such and such, a big court held that the validity of an order must be judged by the reason so mentioned in, it cannot be supplemented by a fresh reason in the shape of affidavit or otherwise. The issue laid down was again followed by the Apex Court in Rasmi Metallic, such and such. In the present case, it may be noticed that in the impugned reply given to the representation of the petitioner, it is not the stand of the respondent that the claim of the petitioner for regularization cannot be considered in view of the oriented such and such. Thus, under the facts and circumstances of the case, in keeping in view of the fact that the petitioner was appointed against a sanctioned post, the OEM issued on such and such cannot come in the way for considering her case. Upon due consideration of the case in its entirety, I am of the view that the case of the petitioner for regularization should be considered by the respondent as a special case, keeping in mind the peculiar facts and circumstances of the case. Non-availability of vacancy in the post of whoever personally cannot be the ground not to consider her regularization. It will be incumbent upon the respondent to create a supernumerary post to accommodate the petitioner for her regularization if so required. The post so created will be personal post and shall cease to exist once a regular vacancy occurs in the petitioner adjusted against such regular vacancy. So the finding in the this honorable court in the earlier proceeding, the finding is against a regular vacancy.
This is date of judgment is 15, date of judgment is
05 to
2020,
my lord,
05 to 2020.
my lord.
Yes.
03, my lord. In my petition parasat. 0302 2020.
0302
2020.
Okay.
Then what happened is that they took full advantage of that to create a separate numeric post.
Yeah.
So it is written to the director, page 33, 15 June 2022. However, one fact remains that, sir, I'm directed to refer to your letter number such and such and the subject cited above into enclosed here with the copy of the meeting minutes of the cabinet held on such and such, conveying its approval for creation of supernumerary posts for recolorization of the service of such and such. Follow-up action may be taken from your end. The direction is not for prospective regularization. 15 June 2022.
Hmm.
34 is the order as per the office letter 15 June 2022. Annexure 9, page 34. Dated 28 June 2022. Number such and such, consequent upon the approval of the government for creation of one supernumerary post for regularization by department, concurrence number such and such, cabinet secretary such and such, home department leader, that is, that includes one, Srimati such and such, appointed as contingency sweeper is hereby regularized with effect from 14 June 2022. Malo, it's an artificial date. Neither it reflects to the 15 June 2022 office letter, nor the date of the order, nor from the actual date of her appointment. So, with effect from 14/6/2022, which is a creation at Mookong branch office, press office under the Directorate of Printing and Stationery in the pay band of such and such, plus all other allowances as admissible under rules enforced from time to time with effect from 14/6/2022. Her service shall be regularized in the old pension scheme with so pension scheme goes back to her initial appointment with the period rendered on fixed pay basis counting towards qualifying service for the purpose of pension benefit as per the details given below. The petitioner, date of appointment, they are very clear, 26/10/1988. Date of regularization, 14/6/2022. As I pointed out, it doesn't stand to any reason. Is it from the date of appointment or from the date of approval given by the government, nor from the date of the order of her regularization?
Have you impugned this order? Have
No.
you impugned this order?
No.
If you are aggrieved by the date of regularization given this
My
order,
lord, no.
have you impugned?
No.
Well, that goes against you.
My lord, I'm seeking, it's a continuation of the earlier proceeding.
You are aggrieved by the date of your regularization, but
My
you
lord.
are continuing to enjoy the scale of pay of regularization.
Yes.
You cannot have the cake and eat it too.
My lord, it's not a question of cake.
It's a question of cake. That phrase applies. You don't want regularization from this date, but you're enjoying the scale of pay from this date.
No, I'm not challenging this order.
Why? You are aggrieved by this order. Your petition itself shows that you are aggrieved by this order.
My lord.
Anyhow, continue.
So when that is my whole case, my lord. Yes. So I am bringing that should be regularized from the date of
Yours is, should
appointment.
be regularized from the date of 26/10/88. Correct? 26/10/1988.
My lord. Even taking the worst view of the matter, just see in 2000 itself, they've given the order.
Okay.
So I leave it up to your lordship.
So your claim is for regularization from
From-
26/10/1988.
My lord. Much obliged.
Yeah, what about all this? These are all.
These are equal
Oh.
before equal work.
Acha, acha.
All these three.
But equal pay for equal work is retrospective. The claim is retrospective.
Prospective.
Retrospective. You cannot claim equal work for equal pay for equal work. Prospective from 28 June 2022. Correct. You are claiming equal pay for equal work only from 26/10/88 to 28/6/2022.
My lord.
Correct.
My lord.
So it is a retrospective.
Yes. But my ruling is only two. That Sharma, Karuna Sharma in Nukiliwa, which that is on the line of regularization.
Okay.
Much obliged.
Okay. I'll come back to you if required. Okay. Mr. Moore, what is your case?
Yes, your lordship.
Let us also see your affidavit. You have filed your affidavit, correct?
I filed my affidavit.
So let
So,
us.
affidavit is a repetition.
Who is this? Okay, respondent 1 to 6.
Yes.
1 to 6.
1 to 6.
So what is your case?
No, your lordship.
Yes.
We have done whatever has to be done. As per the direction of this Honorable High Court in WBC 215 of 2018. And the judgment in order dated 5/02/2020.
Just.
Your
just-
lordship.
Just wait, Mr. Moore. Dated 3/2/2020. Judgment dated 3/2/2020. You have
Yes.
complied with this.
The operating para has just read out by my friend.
Yes.
That is the great essence. There was no box, sanction box to accommodate the petitioner. We have created subliminary box. It was accordingly approved by the state cabinet and he was given the regularization. So, and so far as the WBC 215 is concerned, we have fairly complied with that. Now, for your lordship, for better understanding of the appointment order, which my learned friend has said in 1988, he has repeatedly said that it was a sanction post or it was contested by our state respondent.
In 215.
In WBC 215. Lordship, may I recall the judgment? It's a 10-page judgment only for our understanding. May I read?
The whole judgment?
It
The whole-
begins from page 24, your lordship.
Just wait. Just wait.
Page 24 of the present petition.
Yes.
Actually, this one
Starting from
23.
para?
23, but 23, it starts from 23, Your Lordship.
Para,
No, let me read the whole
judgment.
the judgment, Your
Okay,
Lordship,
okay.
so that Your Lordship will get something
Okay.
out of that.
So many
Why,
things.
why,
Not
why,
only something, so many things.
why this business petition
Ah,
must be dismissed
okay.
at the threshold?
Okay.
Because you see,
Ah,
Lordship, may kindly see the synopsis of it's a one page only,
synopsis of this petition,
this petition,
Of,
206.
the present petition.
Yes, the present petition.
Yes.
Synopsis is very clear. The petitioner, Srimati so-and-so, was temporarily appointed as sweeper against sanction boss. My friend is saying sanction boss. In the office of the Assistant Director, Technical Common Praise Moktrong, on contingency effects be basis on 26/10/1988 and extended from time to time, wherein she is serving as a lone sweeper till date. The petitioner represented to the Director of Printing and Stationery time and again for regularization and scale up pay. However, same was not considered. Therefore, the petitioner approached this court by filing WBC 215/2018, which was disposed of with a direction to regularize the service of the petitioner. Thereafter, the Director Printing and Stationery Department regularized her service with effect from 14/6/2022. Being the lone sweeper in discharging the work of regular sweeper, the petitioner is approaching this honorable court to regularize her service from the date of her appointment and for scale up pay. That is what the main grievance of the petitioner. Now, he is coming to the 1998. From 1998, he should be given skill.
1988.
1988. This is what is buried. Is it, to my mind, it is unimaginable because he was regularized, and as your lordship has found out, he has not impugned this regularization order. Otherwise, he is not satisfied with this order. The regularization order, creation of supplementary and regularization to it seems he is not satisfied with this, but now he's saying that he is satisfied. Then how come he is coming to, he is going back to 1988? That is the thing. So that is the thing which I don't understand, and your lordship may also not understand that. May I read your lordship, beginning from
You're reading the judgment.
the judgment, because
Okay. Yes.
let me start from batch 24.
24. Okay.
Date of hearing 23/1/2020. Date of judgment 03/02/2020. Heard? May I read your lordship?
Yes, please. Yes, please.
Heard, Mr. Unti Longchair, learned counsel for the petitioner, and Mr. V. Yamumi, learned counsel librarian for all the state respondents. The petitioner has come before this court for the second time. The first read petition being WBC 141/2018 was disposed of by order dated 3/8/2018 by directing the petitioner to file fresh representation before the Director of Printing Stationery, County of Nagaland, Kohima, respondent number 5, within a specified period for the respondent number 5 to dispose the same by way of a speaking order within 2 months thereafter. The petitioner filed her representation as directed on 10/8/2018, but the same was rejected by communication so-and-so. Being agreed, the petitioner has filed the instant read petition challenging the rejection of representation for regularization in service, for her regularization in service. The brief facts of the case may be noticed at the outset. The petitioner was appointed temporarily as sweeper in the office of so-and-so, Moktrong, on contingency basis, rupees so-and-so per month by order so-and-so, dated 26/10/1988 by the Director of Printing Stationery, County of Nagaland, respondent number 5. Her appointment was made against the boss sanctioned by order number so-and-so, dated 09/06/1988. Thereafter, the petitioner, having continued as such for nearly 12 years and having not been considered for regularization. She submitted a representation to the respondent number 5, seeking her regularization in service on 16/2/2020. The respondent number 5, white order dated 29/2/2000, issued an order appointing the petitioner temporarily as sweeper under directorate in the scale up so-and-so, along with special compensatory remote locally so-and-so, so-and-so. The respondent number 5 again issued another order on the same day, appointing the petitioner temporarily as sweeper under the directorate in the same scale up pay as was indicated earlier. The only difference was that her appointment was for a period of 6 months. Thereafter, the service of the petitioner having not been regularized despite her representation dated 16/2/2000, the petitioner filed another representation on 10/2/2001 before the respondent number 5. The service of the petitioner in the meantime was extended from time to time by order dated 34/2001 and 17/7/2003, amongst others, showing that she was appointed on contingency basis and on a fixed fee. Her regularization having not been considered, the petitioner filed the first read petition as already stated here and above. Mr. I.M. Delongchar, the learned counsel for the petitioner, submits that although the petitioner was appointed on contingency basis by order dated 26/10/1988, but the fact remains that she was appointed against a sanction post as indicated in her appointment order. The petitioner having been in service since her initial appointment was subsequently appointed again on temporary basis against the same post, but on a scale up pay by 2 orders, both 29/2/2000. He submits that although 2 orders speaks about the appointment of the petitioner in the scale up pay, but the petitioner was not given a scale up fee, but only a fixed fee, which was reversed from time to time. Mr. I.M. Delongchar, however, submits that non-payment of scale up pay cannot come in the way of regularization of the petitioner, inasmuch as the petitioner was appointed against the sanction post, referring to the affidavit in the position of the state respondents, more particularly at para 5 of the seat affidavit. The state council submit that the stand of the respondent is that the 2 identical office orders dated 29/2/2000 passed by the respondent number 5 is not in the office record, and that the same was never given effect to. The further stand is that the petitioner.
I'm sorry to interrupt you. This 29/2/2000 is the granting of a scale of pay.
Yes, but the facts are stated as to
Okay,
how.
Okay.
The further stand taken is that the petitioner's representation was silent about the 2 identical orders, and that she had in fact accepted the extension of her service as contingency paid employee voluntarily, and therefore the claim of the petitioner is without any substance. He submits that such a stand of the state respondent cannot be accepted, inasmuch as non-availability of relevant documents in the office record cannot be the ground for the claim of the petitioner, particularly when it is the respondent number 5 and the department authorities who had issued the appointment orders. Further, in absence of any dispute that the petitioner is working since her initial appointment in the year 1988, and that too against the sanction post, the respondent cannot deny the petitioner from being considered for regularization. The learned counsel for the petitioner has further relied upon the apex court decision rendered in Umatibi so-and-so, referring to the Bara 53 of the said judgment. In particular, the learned counsel submits that as per the apex court in the case of irregular appointments, which are otherwise not illegal appointments, and the employee concerned being duly qualified and appointed against the sanction vacant post, such employee has to be considered for regularization provided he or she has worked for more than 10 years without any intervention of the order of the court or tribunal. Thus, according to the apex court, should be done as a one-time measure. The learned counsel therefore submits that the case of the petitioner is squarely covered by this decision, and she, having rendered her service continuously without any break, since her initial appointment order in the year 1988, and also against the sanction post. The court may direct the respondents to regularize her service. Mr. V. Yamumi, State Counsel, on the other hand, by referring to the affidavit in the position filed by the state respondent, number so-and-so, on 13/1/2020, submits that decides there being no records available in the establishment of respondent number 5 about the appointment of the petitioner against the sanction post. The fact remains that the petitioner is working since her initial appointment on contingency basis and given a monthly remuneration and fixed basis. Referring to the office memorandum dated 17/3/2015, which is regarding the scheme for regularization in the absorption of work charge in casual employees, and also revision of wages. The learned counsel submits that the case of the petitioner is not covered by the scheme. The learned counsel specifically refers to clause 1, Roman 1, as well as the clause 1, Roman 1G of the SID office memorandum, which provides that those work charge and casual employees enjoying scale-up pay and committed 30 years or more continuously as on 1/1/2015 can be considered for regularization. However, those employees who are employed on contingency basis, such as personal, beyond part-time super chocketers, seasonal workers, etc., cannot claim regularization under the said scheme. Therefore, the petitioner having been employed on contingency basis, there is no scope for considering her regularization in service. He thus submits the representation of the petitioner dated 10/8/2018 was rightly rejected by the competent authority through the communication dated 28/9/2018, although the same is not very specific. He submits that there is a specific bar to contingency employee to be considered for regularization, and therefore the petitioner cannot have a legitimate clearance. Under the circumstances, the writ petition being without any merit, the same should be dismissed. I have heard the counsels for the rival parties and I have used the materials available on record. The facts of the case having been narrated above, the same requires no reiteration. Pursuant to the order of this court on such and such and WBC 141/2018, the petitioner filed a representation that the same was disposed of by Indian Order 28/9/2018. The relevant portion of the Indian communication dated 29/9/2018 may be extracted below for refusal, sir, madam, and inviting reference to the subject cited above. I have to inform you that the department is in receipt of your representation dated 10/8/2018, although the order dated 3/8/2018 passed by the Honorable High Court, Kohima bench in the referred case. In this regard, it is observed that you were appointed against certain post by order number such and such dated 09/06/19. This should be 1988. It is written as 68, Your Lordship. However, it is requested to 1988. It's a typing error.
Okay.
However, it is regretted to inform you that the sanction post, which was reflected to have been contained and file number so and so, cannot be traced in the department records after prudent and meticulous search, as the file is almost 30 years old. It is also needless to inform you that there is no vacant post of regular sweeper in the department at present to regularize your service. Therefore, in the given situation, our department does not find any way out to regularize your service. Situated thus, the undersigned can be our department's inability to consider your representation dated 10/8/2018, submitted by you on the strength of the order dated 3/8/2018 of the Honorable High Court, bench to the undersigned. From the above extract, it may be seen that the respondent have not denied that the fact that the petitioner was appointed against the sanction post. They, however, say that the relevant file could not be traced out in the department and that there being no vacant post at present, her service cannot be regularized. The stand of this respondent in the affidavit in opposition, amongst others, is that the regularization scheme does not include those employees who are engaged on a part-time on contingency basis. In this connection, it may be seen that the petitioner was initially engaged by Order 26/10/1988, and she continues to be in her engagement till now. The same can in no way be considered as a part-time employment as to so as to apply clause 1(1)(g) of the Office Memorandum dated 17/3/2015. However, the petitioner undisputedly has sought for her regularization by submitting her representation as early as 16/2/2000 and thereafter on 10/2/2021, and also on 10/8/2018 in terms of the direction of this court. In case of Mohinder so and so, so and so. In case of Mohinder so and so, so and so, the apex court has held that the validity of an order must be judged by the reasons so mentioned and cannot be supplemented by fresh reasons in the shape of an affidavit or otherwise. The issue laid on was again followed in the apex by the apex court and so case. In the present case, it may be noticed that the imbued reply given to the representation of the petitioner is not the stand of the respondents that the claim of the petitioner for regularization cannot be considered in view of the Office Memorandum dated 17/3/2015. Your Lordship is well aware of the Office Memorandum 17/3/2015. That's under the facts and circumstances of the case, and in keeping in view of the fact that the petitioner was appointed against a sanction boss, the Office Memorandum issued 17/3/2025 cannot come in the way for considering her case for regularization. Upon due consideration of the case in its entirety, I am of the view that the case of the petitioner for regularization should be considered by the respondent as a special case, keeping in mind the particular facts and circumstances of the case. Non-availability of the vacancy and the boss of Sweber presently cannot be the ground not to consider her regularization. It will be incumbent upon the respondent to create a supernumerary post to accommodate the petitioner for her regularization, if so required. The post created will be a personal post and shall cease to exist once a regular vacancy occurs and the petitioner adjusts against such regular vacancy. It is therefore ordered accordingly. The respondent number 5, within the period of 3 weeks from the date of the receipt of the certified copy of this order, shall initiate the process of regularization in terms of the direction given here in above, if necessary by obtaining the approval of the administrative department. All the respondents shall cooperate with the process and the entire exercise be completed within a period of 3 months from the date of the receipt of a certified copy of this order. Pending such consideration, the services of the petitioner should not be varied to her disadvantage in any manner. So, Lordship, that is the thing. So, regarding the sanction boss, not sanction boss, whatnot has already been decided in this case. Now, the only issue now here is he is claiming scale up pay from 1998. That is her appointment.
1988.
1988. I'm sorry, Your Lordship. So now that my learned friend, the counsel for the petitioner, is asserting.
Mr. MT, Imchen, can you please excuse me for 2 minutes?
Right? So it's probably out of vision, like 1988.
Nanti PJ like benar.
Yeah.
PJ dia pun masih ada social post Uma Devi Lala, 10 years to cover. So, Uma Devi Lala, 10 years भी दूसरा दिन होगी ना, तभी भी cover तो किसी मत दिली.
Yes, Mr. Mohan.
So, your lordship, my humble submission before your lordship here today is, as you have understood the entire compass of the case. Now, my learned friend for the petitioner is asserting that he should be given. He should be given from 1988 till her retirement. Now that the petitioner is out of the service because she was appointed in 1988. Now, since my friend is asserting,
Oh, petitioner is out of service now.
maybe out of service.
Mr.
Yes.
Okay, let me see.
See, 35 years.
Okay.
Yes.
Where is that order? On completion of 35 years? Any order you have annexed?
No, no.
This petition was filed when she was.
Before, yes, before.
Okay, but petitioner is now.
Yes.
She must be out of the service now.
Because her service was counted from 88.
Yeah, it has to be counted from 88. And in this case.
10, 1988.
Ah.
They are counting.
Okay, okay.
Yes.
Yes, yes, ma'am.
Now, I leave it to the wisdom of your lordship. On the facts is very clear. And now that my learned friend is asserting that he deserves, then one who asserts must prove it. So, since my friend is asserting whether he can prove by available materials, case laws decided by the apex.
What is your stand on law point?
My stand is this petition deserves to be dismissed at the threshold.
Why?
Because I don't find anything retrospective effect giving a regularization with retrospective effect. Regularization is always prospective. Once he is given regularization, only then everything will come. It is equally as good as your lordship, it is equally as good and same as regularization from 1988. How can that be possible? How can that be? So, lordship, that is my humble submission before your lordship.
Yes, any reply? Short?
No, no.
Okay.
Much obliged.
Okay.
Mr. Inti Longchar, the learned counsel for the petitioner, and Mr. Moim Chin, the learned senior government advocate
representing all the state respondents.
for the state respondents. Matter has been heard at length. Judgment and order reserved.
Open.
Much obliged.
You can listen.
Item number 80.
May it please, my lord. Lordship, this is just a short matter where the petitioner is the landowner of standing subdivisional office Atoiz. The petitioner is from Gauhati village and he is the landowner. What has happened is, my lord will kindly come to page, I am annexure 14B. 14B is the page 14. Annexure B is the landowner certificate from the village council.
Okay.
Of Gauhati village, lordship, and the annexure C is the application of the petitioner. This was submitted in since 2018. He applied on landowner basis for appointment on Chokidar post at Atoiz veterinary office against Let Vinto Sema Chokidar who expired, lordship. Now, page 16 is the forwarding letter of the Chief Veterinary and Animal Husbandry Officer to the Director. Here also, lordship will kindly see the CVAH has clearly stated that the petitioner is the landowner. My lord will kindly peruse that. Forwarding application of Sri Inoka Sema, who is seeking appointment to the post of Chowkidar against the resultant vacancy owing to the death of Let Vinto Chowkidar expired at veterinary dispensary Atoiz under CVO Sinheboto. Sir, with reference to the subject above, I have the honor to forward here with application of Sri Inoka Sema, who is seeking appointment to the post of Chowkidar against resultant vacancy owing to the death of Sri Let Vinto Chowkidar expired at veterinary dispensary Atoiz under the establishment of Chief Veterinary and Animal Husbandry Officers in Heboto, who expired on 28/6/2018. It may also be stated that the applicant is the landowner of department land at Atoiz and hence applying for the said post as per the consensus held between the landowners. Hence, this is submitted for favor of your kind information and necessary action. Then, lordship, page 17, annexure E, the Director of Health and Animal Husbandry Veterinary Services forwarded the application of the petitioner to the Commissioner and Secretary to the Government of Nagaland. Is 6 September 2018. Forwarded to the government for necessary action, lordship. Then the annexure one is where lordship 18, page 18, the name of the petitioner is at serial number 1. And those people recommended his candidature, and two is one Vinoto Aye applying for compassionate appointment. There were two candidates, the petitioner, landowner, and Vinoto Aye applying for compassionate appointment. This was forwarded to the respondent government lordship. That is 29/8/18. Now, page 19, annexure G. The administrative approval was given for appointment of Sri Vinoto Aye instead of the petitioner who is the landowner. Administrative approval for appointment of the post of Chowkidar under CV Osunaboto. I am directed to your letter number so and so dated 6 September 2018 on the subject cited above and to convey the approval of the government for appointment of Sri.
This Vinoto Aye is the son of K. Vinito against the expiry vacancy.
Here, Lordship, Vinto Aye. Vinto Aye.
Vinto Aye is the private
Yes,
respondent.
yes, Lordship. Likelihood. Here,
So against the expiry vacancy of
his father. Against the expiry vacancy of late K. Vinto. Vinto, here, since in the father's village district, it is written Vinto Aye, probably Lordship, Vinoto Aye was the son of.
so father's name is Vinito Aye.
Yes, Lordship. Kevin. So the respondent government approval the name of the approve the name of Sri Vinto Aye. This has and necessary appointment order may be kindly issued after observing all formalities from your end and the intimation to this department. Then Lordship annexure H.
Now, Ms. IME, now the question which arises is whether you are maintaining the list of the persons who are supposed to be appointed on compassionate appointment.
Your Lordship.
Lordship here, they did not even appoint him and appointed another respondent number 5. This is again another person.
Whether you are maintaining that list.
Your Lordship, that at the moment I have no knowledge, but then with regard to petitioner seeking appointment on land ownership, in this case, already 3 landowners have been appointed, and this has not been denied by the petitioner also. And as per the government policy, it is stated that it is not the policy of the government to appoint them. And with regard to private respondent, this is another respondent. This is Putoli.
Putoli, another one,
This is
Lordship.
another one.
Another one.
Just wait,
Vinito has nothing to do in this matter, Your Lordship.
Just wait.
One Putoli. Who is not
Who is this Putoli?
Private respondent number.
Yes, who is this Putoli?
I was appointed on compassionate ground in the year 2002. 2002
2000 on fixed pay?
contingency basis.
Contingency basis, okay.
After
Yes.
serving for nearly 17 years, my service was regularized, right?
in this post?
To the post of
Okay,
Jupiter.
okay. So you were actually serving on
Contingency.
contingency basis on compassionate appointment.
Yes, Your Lordship.
Let's see your appointment order. Let me just have a glance.
Appointment order is under challenge, Lordship.
No, let us see the appointment order. The first appointment order, contingency. Where you were appointed on contingency basis.
Annexure D, page number 14.
Your affidavit in opposition.
Yes, Your Lordship.
Yes, wait. Putoli. Yes, annexure,
Annexure D, batch number 14.
annexure D. D, okay. There is no mention that you were appointed on compassionate appointment. Has it been mentioned?
No, Your Lordship, it was not mentioned. Your Lordship, since there was no vacancy for the color post, I was appointed on contingency.
No, but I want to know whether there is any proof to show that you were appointed on compassionate appointment.
No, Your Lordship. But I have submitted applications and in compliance.
Where is your application? Let us see.
Your Lordship, annexure A.
Annexure,
Annexure 10B, page number 10.
page number 10. Let me just see. Page number 10, correct? Page number. Prayer for suitable job on compassionate ground. Okay, totally. Okay. Yes, ma'am, please continue.
Yes, Lordship. So here, in this regard, what the learned government advocate has submitted, my lord will kindly come to.
No. You first finish your case.
Oh, Lordship.
You first finish your case. Let me understand your case first.
So instead of considering the case of the petitioner, who is the landowner, Lordship, this respondent number 5 was appointed.
Okay.
My case is only that. And in response to that, Lordship will kindly refer to my affidavit in reply.
Have you also annexed the office memorandum 16/8/2018?
Oh, of course, Lordship. Everything.
So under which clause you are eligible?
Lordship, under this land, my lord will kindly come to. Then Lordship will kindly come to page
34.
32. Subsequent also issued, and the first one is 5th March 2018, that is 32, next year end. I am covered by.
Just. This is 5th March 2018.
18, Lordship. 3B and 3C. I have never been, our family has never.
Page.
32. Next year end. And my lord will kindly
Yes,
come.
yes. Then what about 34?
First of all, in compliance with this, my lord will kindly come to verification report issued by the head Dibashi additional deputy commissioner office is at page 24. Original verification report is 24. Type out copy is at 25, Lordship. This is the verification report. As directed by the authority, Ato is DB scored verification in respect of Sri Inoka Sema claim for land owner right at veterinary office Atuize. As per verification, it was found that Sri Inoka Sema, son of Nihozu Sema, genuine citizen of Vekohoniu, is the legitimate landowner where veterinary office is situated. There is no objection from any group or individual in his claim for land ownership right, SD Luhovi Sema, that is 17519. Then Lordship will kindly come to page 26. This is issued by the Additional Deputy Commissioner. Ato is in Nagaland. Annexure L, page 26. This is issued by the Additional Deputy Commissioner Ato is in Nagaland. To whom it may concern, this is to certify that Sri Inoka Sema, son of Sri Nihozu Sema of Vekohoniu village, is the landowner of the veterinary office Atoizu town. This certificate is issued basing on the recommendation of Vekohoniu village council and DB's verification report. So this is the additional deputy commissioner's recommendation, and Lordship, thereafter I submitted annexure M, page 27, representation to the director, veterinary and animal husbandry, Nagaland, Lordship. I may not read out because even this has been overruled, and they instead
Yes.
then Lordship, I will pray my Lordship will kindly come to paragraph 5 of my, if I read out this, what the government, Learned Government Advocate submitted is countered. My affidavit in reply, Lordship, to what she has submitted before this honorable
Your-
court. Affidavit in reply to the affidavit in opposition filed by the
Yes,
respondent.
madam, first take me to the averments where you have stated that you have either donated or you have given the. land
Yes,
to the
yes,
government.
Lordship,
Where
that
at?
is. My lord will kindly come to paragraph 3 of my writ petition. That for the establishment of the existing dispensary at Atoizi in the year 1978, by oral agreement in those days, the landowner gave land to the government in consideration of employment to grade 4 posts and contract work arising under the establishment. Since till date, none of the petitioner's family have received any appointment or contract work. On coming to know of existing vacancy of Chokidar due to expiry of late Vinto Sema Chokidar by letter dated 5/7/18, the petitioner applied to the post of Chokidar through proper channel, and to that effect by letter bearing number so and so dated 23rd July 2018, the chief veterinary and animal husbandry officer Zinheboto forwarded the application of the petitioner to the director of animal husbandry and veterinary services, respondent number 3, stating that the petitioner is the landowner of the department land at Atoiz. I have already shown my lord annexure C and D. 4. In pursuant to it, by letter number so and so, the respondent number 3 forwarded the names of the applicants shown at annexure 1 to the Commissioner and Secretary, Department of Animal and Veterinary Services, whereof the petitioner was shown at serial number 1 on land owner basis and at serial number 2, Sri Vinoto Aye, who applied on compassionate ground. So this, then Vinoto Aye was approved. However, instead of neither the petitioner or that Vinoto Ayer, this respondent number 5 was regularized in that resultant vacancy. And the respondent number 5 is not even from Atoizu Lordship or from Vekohoni village. Lordship will kindly appreciate that that is only the short fact of the case, and in my reply to the government, in my affidavit, in reply to the affidavit in opposition, paragraph 5. Page 2, paragraph 5, Lordship. I may be allowed to read out. If I read this 2 paragraph, Lordship, my case is only that, Lordship. I don't have to indulge further.
Paragraph
5. 5. This is in response to the respondent government. That with regard to paragraph 4 of the affidavit in opposition of the respondent number 1, 2, 3, and 4, the petitioner falls under clause 3B and 3C of the scheme adopted by the respondents for appointment of landowners in grade 4, post by notification dated 5/3/2018, covered by clause 3A and clause 3B of office memorandum dated 16/8/2018, and OM bearing number so and so dated 3rd March 2022. Yet willfully, the respondents have violated their own standing notification and OM's further. The land acquisition report dated 8/8/2019 submitted to the respondent by the Chief Veterinary and Animal Husbandry Officer. The 2 acres of land was donated to the department by the landowners in consideration of grade 4 appointment. The land donated was ancestral land of Chophimi clan and Ayami clan, and at the time of donating the land, the 2 clans, each consisting of 2 grandfathers' sibling common holdings, agreed to share 1 post each, grade 4 post, appointment on rotation and accordingly, Sri Kahoto and Sri Hotovi from Chopi clan has been appointed as medicine carrier and contingency chokidar respectively, while from Ayami clan, Sri Hotoku has been appointed as bull attendant, and the remaining one, the turn of the petitioner's family to be appointed. However, even if
Madam,
Lordship,
you have clearly admitted that landowners have been compensated with grade 4 appointment.
that is Lordship, there were two
The government notification says that there shall be no perpetual appointment, and exactly you are doing that. You are claiming for perpetual appointment on the basis of land ownership.
Lordship, my lord will kindly appreciate that there were 4 landowner, 4 appointments were agreed to be given to 2 clan each. So that Chophimi clan has already claimed the 2 land ownership. That is from the Chophimi clan side, that is finished, Lordship. Then on IME side, one from the one family has already been appointed, Lordship. That is admitted.
That is your personal arrangement.
That is already done. And the second post, two posts each. It was divided during those days, Lordship, on oral arrangement, Lordship. My lord will kindly appreciate that. So one Sri Hotoku, that is from another family, has been appointed from another grandfather.
Do you have any right to say that you take this post, I take this post, that man take that post, you take that post? Do you have any right to actually make such a kind of arrangements?
Lordship, that is not me myself, but at the time when the dispensary was established, 2 acres was donated and half was the land of the Ayami clan and half was the land of Chophimi, Lordship. So in that matter, Lordship, that Chophimi clan has already got their appointment, Lordship. At the time, Lordship, on oral, I pray that And only one, I am the last one, last. So two grade 4 posts each to the landowner from Chopimi clan and I am clan. So
That
those-
is contrary to the notification issued by the government, which
Lord-
says that landowners shall be appointed only once.
Yes, Lordship, that is it, but to go by the notification, Lordship, of land ownership scheme, Lordship, when there is only one land that is donated, that is one thing, Lordship. And this only one particular land by an individual landowner, that is okay,
I
Lordship.
understood.
Yes, Lordship.
There are two clans who has donated the land. And from two clans from one clan to have been appointed, from one clan only one has been appointed. And you are seeking for the second post.
Yes, Lordship. That
No.
Chopimi clan has already been given, Lordship.
You are
Then-
relying on the government's notification which is against you.
Lordship, then
Anyhow.
I humbly pray that paragraph 6, this is against the respondent number 5. Here I have stated that with regard to paragraph 6 of the affidavit in opposition of the respondent number 1, 2, 3, and 4, both compassionate appointment and landowner appointment are schemes adopted by the respondent government, but of different entities, and in no way one can never overtake the privileged appointment of the other. While compassionate appointment falls under 50% quota in general vacancy, landowner appointment are only for those private individuals over whose land government building offices has been established. And needless to say, the respondent number 5 was appointed on compassionate ground under general category and have no right to be regularized in the petitioner's landowner post of Chokidar when she is from Dimapur, not a citizen of Atoiz, until that she has not joined her duties as Chokidar at veterinary dispensary Atoiz. She has been appointed regularized in the post, but she has not even joined the post till that at the time of filing this writ petition. Further, the respondent number 5 filed writ petition civil number 29K 2018 to consider her regularization under the scheme of compassionate appointments and cannot take away the right of the petitioner to be appointed under the landowner scheme whatsoever. Apparently, in all the applications submitted by the respondent number 5 to the respondents, she has clearly stated that whenever vacancy arises, the respondents appoint fresh candidates through backdoor instead of regularizing her service, which speaks for itself the illegalities committed by the respondents at the cost of the petitioner's right of appointment on landowner basis. Lordship, I will just humbly submit before this honorable court that at that dispensary that is standing, that is exactly where the present petitioners donated land. The present dispensary that stand is exactly on the land of the present petitioner. Yes, Lordship, there were two grandfathers. That was, and the land were divided into two portions. So both the grandfathers, for the need of the establishment of the dispensary veterinary offices, it was donated, and at present, as certified by the deputy commissioner as well as the village council, Lordship, my land is, the present building stands exactly on the land where the petitioner has donated, Lordship.
Okay. Yes, government.
Yes, government has appointed 3 others, Lordship.
Yes.
Yes, Lordship, on the basis of land ownership, already 3 landowners have been
Where have you
appointed.
stated in your affidavit?
Paragraph 4, Your Lordship, page 3.
Yes, please.
This is based.
Paragraph?
Paragraph 4,
Four.
page 3.
Please read it.
that with regard to the statements made in paragraph 3 of the writ petition, the deponent respectfully states that there is no written records between the
Yes.
department and the landowners for consideration of grade 4 posts, as well as contract work arising under the said establishment. That being clarified on the land status acquisition report in respect of the veterinary dispensary Atoizi under the establishment of CVO's Neboto, it is stated that the said establishment was precisely established during the year 1978 and further upgraded to veterinary dispensary in the year 2018. As the land pata, written agreement, sale deed, or other records, form of record could not be traced out, but based on the verbal inputs, it is to be stated that two grade 4 posts similarly, namely Sri Hotoku bull attendant, Sri Hotovi medicine carrier, and one contingency chokidar, Sri Guhoto, has been accommodated on the basis of land ownership. This is based on the status report submitted by the Chief Veterinary Officer, Your Lordship.
Where is the
Annexure
status
A,
report?
Annexure A, page 7.
Annexure?
A, page 7.
7.
This is the land status report submitted by the Chief Veterinary Officer. The last paragraph
Just
states.
wait. Yes.
From page 7, Annexure A, the last paragraph, title compensation. Here it has been stated, it is assumed that two grade 4 posts, Hotoku bull attendant, Hotovi medicine carrier, and one contingency chokidar, namely Kuhoto, have been accommodated to the landowners. And this has not been denied by the petitioners, Your Lordship.
Yes, Lordship, that is.
They have admitted in their reply.
Yes, Your Lordship.
Yes.
And Your Lordship, coming to the private respondent number 5's appointment, Your Lordship, regularization.
Yeah.
She was appointed.
Where have you stated?
Paragraph 6, page 4.
Yes.
Paragraph 6, the 9th line, page 4. Therefore, it starts with therefore on the 9th line.
That with regard to the statement. Para 7.
Yes, paragraph. Okay, then I'll read from the beginning. That with regard to the statement made in paragraph 7 of the petition, the deponent respectfully states that the respondent number 5's husband, late Ian Nito Jimomi, expired on 26/2001, leaving behind his wife and 5 minor children, and accordingly, respondent number 5 sought appointment on compassionate ground. However, she was appointed to the post of attendant on contingency basis, fixed pay in the year 25/6/2002 instead of regular service as per the scheme. Therefore, the respondent number 5 filed the writ petition number 29K 2018 for consideration of a matter and as per the scheme on compassionate appointment. The respondent number 2 and 3 on examination of a case found it to be genuine and considered for regularization of a service against a regular post. And to that effect, the High Honorable Court, by order dated 23/8/2018, disposed of the said case with the direction that the state respondents to consider regularization of the petitioner's case against a regular post within 4 months. So the service of the respondent number 5 was regularized to the post of Chogita at veterinary dispensary Atoizi. The court order is annexed as Annexure B.
Okay.
That's all, Your Lordship.
Lordship, my humble prayer is that for
Let us hear the private respondent. After that, we give you the time.
Lordship.
Yes. Have you filed your affidavit?
Yes, Your Lordship.
You are respondent number 5.
Yes, sir.
Where's your affidavit? Let me go see that. Respondent number 5. Have you enclosed the scheme for compassionate appointment?
No, Your Lordship.
Do you have a copy? 17/9/2015. Compassionate appointment scheme.
No, Your Lordship, I didn't annex.
Kindly trace out and give a copy in my chamber. Your paragraph Roman 2. Office memorandum 17/9/2015. Kindly trace out this, give me a copy of this office memorandum in my chamber. Miss Avitoli or any one of you. Today itself, 17/9/2015. You see your Roman at page 3, Roman 2. Your paragraph 5, Roman, paragraph 5, subclause 2.
Yes, Your Lordship.
Yes, what is your case?
Your Lordship, as stated by the government council, I was appointed on compassionate ground against the boss of my late husband. And during the time of my appointment, since there was no regular boss available at that point of time, I was appointed on contingency basis. But I was given assurance by the department that my service would be regularized as and when vacancy arises.
Where is that ever?
Your Lordship, I've stated in my affidavit.
In which para have you stated that?
Paragraph 5, Roman 4, page 4, Roman number 4. Your Lordship, I may be allowed to read it out.
Yes.
Your Lordship, that the answering deponent respectfully states that as per the scheme, the answering deponent was ought to have been appointed on regular basis. However, she was appointed as attendant on contingency basis since there was no regular boss at that present point of time. However, the answering deponent was given assurance by the department that her service will be regularized as and when vacancy arises in the department. Your Lordship, the answering deponent was under the legitimate expectation that her service would be regularized. However, on several occasions, she was denied the opportunity and preference was always given to others. In between, the answering department had also submitted several applications before the department praying for regularization of her service. However, her prayer for regularization was not considered. Therefore, being aggrieved, the answering department had approached this honorable court by way of filing a writ petition being numbered as WBC number 29K of 2018, praying for regularization of her service. Accordingly, this honorable court by judgment and order dated 23/8/2018 Your Lordship, I have annexed it as Annexure F to my affidavit. Was pleased to dispose of the petition with the direction to the state respondents to consider regularization of my service against a recolor post within a period of 4 months. And in compliance to the court order, judgment and order, the department write order dated 9/3/2019, Annexure G to my affidavit. My service was regularized to the post of Jupiter at veterinary dispensary at Atuzio under the establishment of Chief Veterinary and Animal Husbandry Officer Zenepoto. Your Lordship, the petitioner had also made the contention that I am an outsider. However, Your Lordship, I am also an indigenous inhabitant of Zenepoto district, and I have every right to be appointed to the said post of
You have stated that
Jupiter.
in para 8.
Yes,
You have stated that in para 8.
Yes, Your Lordship. And I've annexed my indigenous certificate also. Annexure H, batch number 25. Your Lordship,
Where is that indigenous certificate?
Annexure H, batch number 25. Your Lordship, my humble submission before this honorable court is that I was appointed on compassionate ground, and after serving the department for nearly 17 years, my service was regularized to the present post as per the direction passed by this honorable court by judgment and order dated 23/8/2018. Your Lordship, as such, the question of setting aside my appointment order does not arise. That's all, Your Lordship.
Yes.
Lordship, my just winding up submission is that my lord will kindly acknowledge the my position that 4 persons, 4 individuals donated land, and
Yes, that this court has understood.
three has already been given, and I am the only one, and I also have donated my land, Lordship. That is one aspect. So though the scheme shows an individual donation specified, likely individual donation, here the dispensary was donated by 4 individuals, Lordship. So
Madam, if your claim is opposed to the scheme, how will this court accommodate you? That is the issue. You yourself, you have actually admitted that only one from your clan have been appointed. The scheme says only one. There shall be no perpetual appointment from the land owners.
Lordship.
Once one of the landowner is appointed, that will suffice the scheme.
Lordship, that will be a donation by an individual. My lord will kindly pray that and the regularization of the respondent number 5 is after all this, the petitioner has approached the respondent government, and after they have taken cognizance of my application, and Lordship will also appreciate that even the district administration, who is the authority, has already certified that, forgetting about the past appointments, but they have already certified that I am the landowner of the existing.
That verification certificate itself is against the policy of the government. Anyhow, I have heard you.
Lordship.
Heard MS Z. Jimomi, the learned counsel for the petitioner. MS AIME, the learned government advocate for the state respondents, and MS
And Inasila.
so and so, learned counsel for the respondent number 5. Case heard in light, judgment and order reserved. 73 service. Yes. Bicara dulu ya, ke situ.
Continue.